Hi everyone, and welcome back to our channel. My name is Tony, and believe it or not, but I'm right now in Istanbul, Turkey. This is, of course, as you know, is a city of at least 2,000 years of human history, but it is also a possible crypto hub for the future. At least we know that the government of Turkey has passed a new law on digital assets, and there are many events, and the crypto industry here is very vibrant. And we will definitely talk about Turkey in one of our future videos, but this video will not be about Turkey. It will be more about crypto, and actually about one of the most important events that happened with crypto this year. And I'm talking about two complaints that have been filed by SEC against Binance and Coinbase. Binance, as you know, is the world's largest crypto exchange, and Coinbase is the largest crypto exchange in the United States. So obviously the complaints like that can have a huge impact on the community and on the industry, not only in the US, but also globally. And that's why everyone is so nervous. But on the other hand, the SEC's position in Binance Coinbase dispute is a bit not that strong, given the fact that we have a partial loss of SEC in the Ripple case that happened also in summer of this year. This opens up a lot of legal questions, purely legal questions, such as, for example, how strong is the position of SEC in Binance Coinbase disputes, given the fact that we have this partial loss in Ripple? Then what will be the time frame of the both proceedings? And what will be the possible consequences and possible outcomes of the both disputes for the US and for the global crypto industry? We decided to talk about that with our friend, the friend of our channel, and the expert that you probably saw in our previous video about Bittrex, the US attorney based in New York and practicing a lot of crypto cases, Tim Dunfey. And here is our discussion with Tim. Hello, Tim. It's very nice to see you again and discuss various interesting topics that are relevant to compliance realm. And today our topic is what is happening in the two cases that are related to, let's say, the whole fate of crypto industry in the US and maybe beyond the US, I guess, which is the two complaints, one against Binance and another against Coinbase. So in general, Tim, what is your perception of what is going on right now with Binance and Coinbase cases?
Well, you know, they're each their own individual cases, right? I mean, these are probably the three big cases going on right now. They're each unique with their own, unique set of facts, right? Cases are driven by facts, and so those three cases are working their way through the system. And, at the end of the day, as you've kind of said, here in the US, we have a civil system versus a criminal system. These are civil cases. And so the idea is that, if anyone has been wronged, there would be some monetary, payment back, right? Whether it's disgorgement of assets or whatever the case may be, that there would be that recovery, right? That positive recovery. It's really driven by, right, the Securities and Exchange Commission. So, here in the US, we had the experience of the stock market crash in 1929, where, it was the first time Wall Street had crashed and they had taken people's money, normal people, consumers' money. And so it was recognized that if you were going to have these public markets like the New York Stock Exchange, that you needed some oversight to protect regular everyday investors. And so this is where, the concept comes from, the idea that investors would be protected by the idea that you would have to, register as an exchange. You just can't set up an exchange and take people's money in exchange, right? Securities. You have to register, right? And you can't sell securities without being registered. So we're getting back to the idea of, you got to fit in, you got to fall in line with the system, and the system is there to protect consumers. So all of these three cases are really about consumer protection at their heart.
Just okay, we can start from this angle, I guess. I just read several reports about, let's say, on Bloomberg and other places, alleging that when it comes to cryptocurrency exchanges, the problem is that they are actually to a certain extent unable to be registered properly with the SEC. So it's kind of like a black joke when the SEC, for example, files this complaint, for example, against Binance or against Coinbase, requiring them to register with the SEC, because when they try to register, they probably will not be eligible for the criteria related to, that are established for normal, companies that are selling securities. For example, when it comes to Coinbase, one of the problems with Coinbase is that it's a broker. It's at the same time the exchange, and it's at the same time the clearinghouse. And so this is one of the key things about Coinbase that we know. And it's really hard to imagine that Coinbase is able to divide these functions in itself. And I guess that probably each cryptocurrency exchange operates the same way. So both cases were filed, the complaints were filed in June 2023. I guess the case against Binance was filed on June 5th, and then the case against Coinbase June 6th. In different courts, but still, what do you think? How long will be the procedure in the procedures in both cases? What would be the most possible timeline when we can be
most possible? I mean, these cases could go on for years. I mean, I don't want to say a decade, but I mean, 5 years would not be unrealistic, right? I mean, in the meantime, they may continue to operate. Right, as Binance was given allowed to operate under an order, right? And so they're allowed to continue to operate as long as they repatriated, right, those funds to the U.S. That were for U.S. account holders. So they can go on operating, right, throughout this time period as the litigation continues.
But for example, let's say with the Ripple case, we had, I think it was filed in 2020, and we got the order for summary judgment. Basically, there were two motions for summary judgment on both sides, and we got this order in 2023. So it's 3 years. Given the fact that's pretty quick. Well,
and that's a summary judgment, right?
It's a summary judgment, right? Yeah. So here we have, as far as I see, in both cases, the trial, the jury trial is requested. So this means that there will be actual juries collected there somehow. So there will be a very long procedure, I guess.
At least at this point, right? I mean, they could change their mind, right, in the future, and decide that they'd rather have a judge decide this, or the judge could appoint a special master, right? Somebody who has subject matter expertise so specific in this area that he would be better to decide. Judges have a fairly wide range of options there, but yeah, I mean, it could go the whole way, right? It could take years, and it could be a jury trial, and it's a long time.
Right.
It could take a while.
In both cases, we have the relief sought includes the injunction, the permanent injunction, basically to operate with, let's say in an unregistered mode. Let's say civil penalties. We have disgorgement of ill-gotten gains. So all of this relief, all of this remedies, right? They can be judged only based on the jury verdict, right?
Remedies, no, the judge, right? That's a whole separate piece, right? The remedies can be a separate piece. So it's kind of like the sentencing in a criminal trial. It could come later. So they could reach a verdict and then have to, at a later date, decide what the remedies are.
Okay, so this means that in any case, at any time before the jury trial, we will not see any permanent injunction order or anything like that. So it will be quite a long procedure.
You would think, but things do happen, right? I mean, I think we have a situation with Binance where they've been asked to repatriate the funds and create these new wallets within 2 weeks. And so, if they violate the judge's order, right? Because in the meantime, the judge can make an order, right? For stopping them from doing something or whatever. And so, they could violate the judge's order in the meantime, and you'd be found in contempt of court, and things could change, right?
So SEC, for example, in Binance case, that's correct. The Binance case, SEC filed an emergency motion for this trading order basically, which, as far as I understand, it partially relates to the repatriation of funds, and also to basically it's like an emergency injunction, so that Binance cannot operate in an, I guess, in an unregistered mode.
No, it's saying that
Mhm.
you can continue to operate as long as the funds that belong to U.S. account holders are
Mhm.
brought back to the U.S. so that these account holders are
Mhm.
protected from your ultimate what whether you go out of business, you don't have the funds, you give the funds to somebody else. I mean, it comes back to the one of the underlying issues in the Coinbase case is the
Mhm.
custodian relationship, and
Right.
that's where a lot of this goes back to. Is the idea that you, as a custodian, you can't commingle these funds with other funds. The money has to be there for the owners, right? When you're holding yourself out as a custodian. So, right, it's
Mhm.
the U.S. right, Securities and Exchange are trying to protect U.S. citizens who have accounts to make sure that their money's actually going to be there.
As far as we read the memo from the defendant side, the Binance defendant side, we see that it specifically opposes this emergency motion. So they are basically trying to say that all the allegations that are made by the SEC are not based on anything except that there are some fears about what is happening, and on certain declarations made by SEC accountants who were trying to basically track down certain transactions that have been done by Binance. But as far as I understand, there is no clear evidence whether or not Binance actually used the funds of the users, of the investors, when they were moving this money, which is a lot of money as far as I understand. It's like $800 million, something like that. But still, there is no specific evidence that this money were not, let's say, Zhao's money or Binance money. What do you think about this position?
I mean, I looked at the complaint, and it had a lot of the different entities that were involved. I think this comes on the heels of an investigation by the Securities and Exchange Commission, right? They
Mm-hmm.
didn't just show up in court. So, I mean, look, I mean, it's what they can prove versus what Binance can prove,
Mm-hmm.
and you as in any business, right, there are accounting formalities,
Mm-hmm.
and you need to have records of the transactions that you did, and if Binance can produce records that shows that they didn't commingle these funds and that they didn't that they did adhere to sound accounting principles, then they would be able to prove their case, and vice versa. If the forensic accountants that have been hired by the Securities and Exchange Commission,
Mm-hmm.
who by all appearances from the complaint have done some investigation at least, or right. So I mean, it comes down to what are the facts, right? And that's what the judge is going to decide.
In fact, what they're trying to say is basically that Binance is a global exchange. Zhao is not a resident of the U.S. He resides in Emirates. Most of the Binance business is outside the U.S. Is it possible to somehow, avoid U.S. jurisdiction in similar cases as what is happening right now with Binance?
Well, I mean, look, I absolutely, yeah, if you can operate outside the U.S., you'll be outside the U.S. jurisdiction, right? I mean,
Mm-hmm.
but at the same time, I don't think the U.S. is alone in
Mm-hmm.
where it's going in terms of increasing oversight of the industry. If you want to have greater acceptance and more participation by rank and file consumers, then you're going to have to accept greater regulation. I mean, it's just part and parcel of maturity.
In terms of Coinbase, we see that Coinbase has a separate proceedings against SEC. And as far as I understand, there were like 5 digital asset related rulemaking petitions to the SEC since 2017. And as Coinbase states that SEC has not acted as regards any of those petitions. So what do you think? What do you think this kind of like line of argumentation, does it have any value in the main procedure, in the main case, in the trial related to Coinbase?
I think obviously, I think it would have value, but
Mhm.
unfortunately, the SEC is, you know, law is made in a number of different ways, right? I mean, we could have Congress pass a law, right, that
Mhm.
clarified it, right, and they could write a law that specifically gave guidance. Now, mind you, as soon as they give guidance, somebody could come out with a product that didn't clearly fit the guidance, right?
Mhm.
Tomorrow, you know how dynamic
Yeah,
the
of
world
course.
of digital assets is. I mean, literally, somebody could invent something tomorrow, right? That didn't comply the day after the law came out. And so we would then be relying on a judge to figure out, does it apply or does it not apply? And then, where does it fall? And so we'd rely on a judge to make the decision. And so, to this point, they've relied on, very old case law, the Howey test, right? It's
Yeah.
amazing how something so 5 points have stood the test of time this long.
Mhm.
And really, if you look at the Ripple case, where they split the baby, so to say, right? In one part of the case, they say this part of your portfolio, but this part of what you did fits the Howey test because you went to, and it's a security, right? So in this
Mhm.
instance, Ripple was a security
Mhm.
because you went out to hedge funds and you offered it to them, and hedge funds aren't doing this for for the fun of it. They're doing this
Yep.
to make money. And they're not going to do anything, right? They're relying on you. It's your efforts that's going to make this hedge fund money. Crypto is that way. In some cases, it's going to come across as a commodity. Some cases, it's going to come across as a security. And some cases, it may show up as a currency.
One of the arguments of Ripple in the case was fair notice, meaning that SSC violated the due process rights Coinbase. You cannot regulate persons without giving them the fair notice that the conduct is forbidden or required, et cetera, et cetera. This is Fifth Amendment. And I guess the judge in Ripple case kind of like discussed that and looked into specific evidence related to whether or not the that Ripple and the CEO of Ripple actually looked into the question whether or not what they're doing is creating securities, and it seemed that actually they did quite a lot, and because of that we see that right now SEC drops any charges. So how do you think, is this the fair notice argument a valid argument?
When I first,
Mm,
2, 3 years
mm,
ago, when this
mm,
case first came out, I thought
mm,
that was going to be, I thought Ripple would win, and it would be,
mm,
XRP would win, and it would
mm,
be because of the fair notice
mm.
deal. Because back in 2007, remember,
Yeah.
Ripple XRP was the first, civil enforcement action by FinCEN against a crypto exchange
Hmm.
because they didn't have a money laundering program in place.
Yep.
And so my thought was, at least at the time, was that
Mm,
that because that was the SEC's chance to raise the securities issue, and that because they didn't do it then, they'd missed their chance. But I don't know what all, we're in the initial stages of the Coinbase case, and so it hasn't all
mm,
come out. But what did Coinbase do to gain assurances that what they were doing is, legal and acceptable, et cetera? As these things come out, it comes down to the facts always, right? But as a business grows so quickly and so rapidly, it's hard to implement formal processes.
Another procedural question is that Coinbase moved for judgment on pleadings. That's one of the, I guess, crux at the moment. One of the key elements of the what is going on basically in Coinbase case. They moved for judgment on pleadings, and Coinbase right now, I guess literally today on Tuesday, has a filing deadline for the answer to the SEC's rebuttal on the company's motion. And the motion basically, as far as I get the memorandum, is basically saying that SSC doesn't have any clear evidence about anything what they're stating, and so we don't need the jury trial at the moment. We just need to have a decision based on what is pled at the moment. Can you give a bit more detail on this specific motion, how it works?
Sure. So, the easiest, right? The easiest motion would be the summary judgment, right?
Hmm.
Finding on some. So, in other words, there's no legal issue here, right? That would be easier. Would be there's a summary judgment. There's no legal issue here, no case.
Hmm.
Motion on the pleadings is okay. The other side has a case, but we have been able to answer all of their legal issues based on our research and what we've done. And so we've given you, Judge, all the information that you need here to decide the case. And so that would be the next kind of easiest way out of it for Coinbase, right? Is to have a motion on the pleadings. It's every lawyer's dream, right? You've written your motion so perfectly, your response so perfectly, and you've found the law that is so applicable to your facts and these facts that the judge is going to look at this and say, wow, this is fantastic. You're free to go.
Okay, now returning to the merits of the two complaints, they are largely identical because both Binance and Coinbase, they list one and the same, let's say, instruments, one and the same tokens, and they include some of the very troubling things. One of them is definitely BUSD. How do you think, like, what's the logic behind that?
The issue is that you aren't backing it up, right? I mean, it comes back to a tether issue where, if you say, to go back a little bit in time, back, I guess it was 2020, when the Basel committee came out with a segregation or a risk rating or risk assessment of different types of cryptocurrencies. And at one end, they put Bitcoin, right, as the most high risk, having the most risk. In the middle, they put stable coins, right? And on the other end, they put central bank digital, CBDC, central bank digital currency. So the US and the stable implementation of the stable coin regime that we're going through now, they have required, so the ones like the Circle, USD coin, is supposed to be backed dollar for dollar by assets on deposit at a federally insured financial, institution. And there is an accounting that every dollar is backed up, right? And there's monthly reporting between the financial institution and the issuer of USD to make sure that, the values are the same. And so the issue, to go back to Tether, that Tether got in was that they were too successful. They couldn't get enough dollars to back them up. And so they kind of slid back in their reasoning and said, well, we're not dollar for dollar. What we have is enough liquidity to meet our demand of withdrawal, is kind of how they fell back. And they entered into an agreement with the NYDFS that they would agree that they had violated what they had said, and that they would, try to stick to that. But, if Tether had collapsed at the time, I think Tether was like the 45th largest bank in the U.S. If they had gone broke. And I think there was a systemic risk there, that would have created a greater panic in the crypto world, and then there would have been a more, complete collapse. But it was a wake-up call for all of those who were offering digital assets more broadly to have an accounting to your customers that you actually do have their Bitcoin when they're going to come and they're going to ask for it.
It's not just clear for me how exactly this specific BUSD, being a stable coin, can be covered by can satisfy the Howey test.
So that's what Circle said, right? So Circle filed a brief. Circle's brief was supported neither side, right? They came out in the middle and said, we are not supporting these guys, but what we will say is, how did you get? Yeah, we're not them, right? We're not a security. U.S. Stable coin shouldn't be considered security. So your reasoning is right in line with what Circle's reasoning is, and USD.
Right, and in fact, basically most of the tokens that have been mentioned by the SEC in both cases, they are proof of stake tokens. This means that one of the things that you can do, owning such a token, such a coin, you can stake it. This means that you can use it for verification of other transactions in the blockchain and gain certain rewards out of that. Do you like this argument?
We keep splitting the hair of security finer and finer and finer as we go along. And as I said earlier, you can come up with something tomorrow that would, immediately invalidate any law that would come out to clarify this. So it is a bit of a moving target. I'm glad I'm not the one having to decide this, right? Only by relying on other people in the value chain, right? And can you provide a level of, separation of duties, and then import on those other parties their duties, right, under these agreements that would provide, a check, right, against the potential abuses, right, that could take place when you have all of these parties commingled. And so I think it begs back to the need for greater regulatory clarity, and it's not just the definition of security that matters here, right? It's who can be a broker, who can be an exchange. What are the duties of the exchanges?
When it comes to specific drafting of the two complaints, they just enumerate certain points, and if you look at the specific, let's say, reasoning, we don't see much of the, let's say, application of the law to facts. Do you like the way how the complaints were written in this part?
You know how it is. You're an attorney, right? You write a lot of things, and not all of it do you like. Right. Sometimes you end up settling on something, and this may be a case of them settling on language that didn't interfere with other things that are going on. I think what you're seeing is purposeful avoidance more than the lack of effort to,
I also think so. Yeah, I also think so.
Oh, and by the way, just recently in this October, Sumsub has issued a data-driven report on the verifications and regulations in the crypto industry. It's called the State of the Verification and Monitoring for the crypto industry in 2023. In this report, we have analyzed more than 100 companies. We have studied more than 1 million checks, and we have analyzed more than 800,000 fraud attempts. So if you want to learn more about the real verification challenges that the crypto companies actually faced in 2023 and the tips how to overcome these challenges, click on the link below the video and download your copy of the report. Thank you.
In Ripple case, we see this distinction between what is called the institutional sales, when you have a direct relationship between Ripple and investors, where you have this expectation and promise of certain profits, and at the same time, what is called the programmatic sales, where basically random customers were buying these XRPs from random parties again, and they at certain time, in certain cases, they just didn't know about Ripple, that Ripple even existed. So do you see any potential in this type of, let's say, transactions, so that if coins, for example, were disseminated by third parties in some kind of a programmatic deals, this would mean that those coins are not securities for the purposes of these types of sales?
When they go into the institutional sales, they specifically refer to sales material that they presented to various hedge funds. And the sales material, they were, declaring the investment value. Now, I met with Ripple very early on, and Ripple was explained to me as something that would never have value. It was going to be used for conducting transactions, right? It was going to compete with wire activity, and it was going to be a payment protocol. It's just for payments. And, as one of the downsides of Bitcoin is as the value increases, right, it gets too large. It doesn't make sense for a payment because of the fluctuation in value. So what I was explained to me in the original white paper for Ripple was that this would not have value. It would always be used for exchanges only, and as soon as it got to be too valuable, they would issue more of it, driving down the price, making it useful for conducting transactions. So that was what I was told the use case was for Ripple very early on, and it would never have value, right? But of course it grew in value, did have value, and they made hundreds of millions of dollars. To your point is, there are two kind of diverging stories of what Ripple is. One, the original use case, no value ever, and you have people buying it, right, just programmatically or
Mm-hmm.
you know, without being sold, right? Without being told what the purpose was. And then right, and then you have this other use case where they're going to hedge funds and saying, jump on the bandwagon because this is going to be valuable.
What do you think then? What would be the destiny of NFTs, for example, especially NFTs like artworks?
You know, I mean, art, right? I mean, once again, you know, print, right? Print art is not a security. Right? I can make 100. You know, Salvador Dali can make 100 prints. Then we get to back to the rolls, right? I mean, but now there's 100 of them out there, and somebody's offering an exchange, right? So now, if you're an exchange for these, your role has changed. Your responsibilities, you know, therefore should have changed, right? I mean, wash sales and these things, right? Or, and you know, I mean, you know, if you've done any review of NFTs, you understand that you can inflate the value of an NFT by selling it to yourself.
But this means that we're wiping off any distinctions, any bright line between securities and commodities in the end of the day.
Yeah, I mean, I think, you know, 10 years, 15 years into this, we're still begging for a law.
Tim, what do you think would be the outcome in Coinbase trial?
I think Coinbase has a great business. They're not going anywhere. I think they grew too fast. They didn't adhere to, you know, standard accounting principles. They kept taking money, and they kept, you know, so they weren't tracking their money, and they'll pay the fine and fall in line.
What about Binance? What do you think will be with Binance?
I think Binance will leave the U.S. I think Binance will leave the U.S. They their market is outside the U.S. anyway.
Thank you very much, Tim. I think that was
very
fruitful, very interesting discussion. Thank you very much. And next time we'll be
always fun,
happy
Tony.
to talk again. Always. Thank you.
Ciao.
Bye-bye.
So this is our discussion with Tim. I find it quite optimistic in the sense that the proceedings will take a lot of time. So probably we're going to have time to prepare ourselves for the consequences that can be unfolding out of these decisions. So it's not like the catastrophe that will happen tomorrow. But on the other hand, obviously, we see some kind of like a Pandora box that can open up out of the possible decision that any token can be a security. I have my personal views on this topic. I will share it in the next video. If you like the video, please smack the button I like. If you want to discuss the topic and share some comments, please leave the comment below. Otherwise, thank you very much for your attention and take care.